Welcome. This is Najma Minhas with Global Village Space. I'm joined today by Barrister Ahmad Pansota to look at the Supreme Court decision on the presidential reference on Article 63A, which was with the court for over 58 days. Ahmed, the Supreme Court had 4 questions in front of it, and I'd just like to look at those questions. Will defectors be allowed to vote? Will defectors members' vote be counted? How long will they be disqualified for? And what are the measures that can be taken to prevent defection, floor crossing, and vote buying? What are your, let's go through these 4 questions.
You see, first of all, the question that Supreme Court had to consider was the very applicability of Article 63A of the Constitution of Pakistan. So, in the short order that we've seen, I would like to answer question number 1 and 2 together. Why? Because first of all, the importance of 63A has been discussed, and the Honorable Supreme Court, with of course a split decision of 3-2, the decision that has been announced is that Article 63A cannot be read in isolation. This is an article in the Constitution which is punitive in nature, and basically it is restrictive. So, that particular perception that was being created by the government and by all others in media, that it is an article whereby you can just be punished, deseated, and this does not stop you from voting, has been this notion has been dispelled by the Honorable Supreme Court. And while doing that, the Honorable Supreme Court has held that a purposive approach has to be taken. And I'll tell you the difference between purposive and literal approach. There are various tools for the interpretation of the Constitution of Pakistan. A, there is literal rule. You literally try and interpret the Constitution if the wordings are very clear. However, if you are unable to do that or to achieve the very purpose of the legislative intent, then you move on to the purposive approach. The Supreme Court of Pakistan has taken the purposive approach here, and in doing so, they have held that A, Article 63A is unique and must be read in conjunction with the other articles in the Constitution, meaning thereby that the votes that these dissidents had casted, or the votes which was cast, that will not have any value. Why? Because it is considered or it is deemed that they did not vote. Now there is a difference between the National Assembly and the Provincial Assembly, because in Provincial Assembly votes were cast. However, in the National Assembly there was no votes cast. So the difference would then arise as to the very applicability which the Honorable Supreme Court of Pakistan has made abundantly clear that these votes will not count.
Okay, sorry. So I just want to understand the Supreme Court's decision. Is it clarifying that after a defector, after a MNA or MPA vote, and if they defect on the basis of that vote, that's where defection will be counted, not that the intention was to vote against the Prime Minister or the intention is to vote against the party line on those 4 instances?
You see, Article 63A is very unique. To answer that question, we need to understand the legislative intent and the background behind this article and the available material we have in form of the short order of the Supreme Court of Pakistan. What has happened was that in 2002, Political Orders Act, Political Parties Order, there was a need which was felt that people should not be allowed to floor cross. And then eventually in 2010, when you see the 18th Amendment was passed, it was categorically mentioned in that anybody who tries to change his political affiliations or tries to vote against the party line, which is if the head of the party has issued a party line, then that will not be allowed, or that should not be possible. Now, the question for the Supreme Court was to consider whether it is restrictive or punitive, whether a member is restricted from voting or he can vote, but then he will be punished. Supreme Court of Pakistan has taken a very, very different view, which I have been propagating for a long time. Why? Because Supreme Court here feels that it is couched in a way, or the language of the article is couched in a way that it restricts you from voting. It does not say that you will be, the actions will be taken. Supreme Court, from whatever information that I can gather of the order, I feel what Supreme Court essentially will be dilating upon in their detailed order is that the de-seating process after that is merely a process that follows it. It is more of a formality that follows it. However,
So you
if somebody tries to do that,
clarify,
it won't be.
Emma, sorry, I just want to clarify. Are you saying then the Supreme Court's going to look at the person's intention? So in the scenario of the MNAs in the National Assembly who have not yet voted, because they made a statement, a press statement saying that they've just more or less left the party, would the Supreme Court then consider that as defection, and therefore they should be unseated, depending on what the ECP says?
Well, that's a different situation. In my understanding, I don't think so. The order is clear to that effect. However, short order is very clear to the effect that they cannot vote. It is not about voting and then something happening. The order is very clear. It says that they cannot vote. They ought not to have voted. Here, this is a second situation which is slightly unclear, and I think the detailed judgment would clarify that. And that the part is when somebody changes the political party, because that is also mentioned in 63A. This is where the dissidents in the National Assembly become relevant. So if you say that political party or change of political party, I am sure Supreme Court's judgment would like, obviously dilate upon that as well. But I would not like to predict. But in my humble understanding, I believe when you express your intent or your intention to change a political party, and more specifically, one of the dissidents that said that he has been promised a party ticket from a particular party, then in that event, that would also amount to defection, as far as my humble view is concerned. And Supreme Court's order, however, is yet to be seen because a detailed judgment is obviously on its way. And once that comes out, I think questions like these will then be answered.
And what about this, the second and the third question, which was, let me just add that. How long will the defectors be disqualified for?
Well, I'll be very honest. As far as my analysis is concerned, I was very clear from day one that this is not the Supreme Court of Pakistan's job to read in anything in the Constitution of Pakistan. Anything which is not mentioned in the Constitution of Pakistan, it is not Supreme Court's job to do that, and that's exactly what the Supreme Court of Pakistan has done. They've said that Parliament must legislate on this subject. They must define a term for punishment. It can be lifetime, it can be 5 years, 10 years, depending on whatever the parliament says. Why? There is a reason for that. And the reason is that parliament included this article in the constitution. So parliament is the best judge to understand the legislative intent behind it. And as far as I am concerned, what I understand when I went through the Hansards, as they call it in England, or the you see the debates in Pakistan, my point of view was very clear that Raza Rabbani and likes and many other people who were part of that process, they were dead against the very concept of law crossing. So from that point of view, if you were to look at it, I think the punishment will be grave. However, as somebody who believes in the Constitution of Pakistan and a law-abiding citizen, and also the principles of Islamic law, I don't think so. Any punishment should be grave enough to sort of limit somebody's political career for life. It should be time bound. Anybody can make mistakes. It is not a murder. It is not anything of that sort. So it should be time bound so that somebody who makes this mistake or an offense or a constitutional violation
Right.
should be in a position to come back after being, going through a reformatory process, I would say.
Okay, so but the Supreme Court's left that for Parliament to legislate on. Okay, so if we go back to the fact that the Supreme Court has said that any defectors' vote will not count, what are the implications this now has for Punjab and for the Chief Minister Hamza Shahbaz Sharif's election?
Well, in my view, the election of Mr. Hamza Shahbaz Sharif suffers from a lot of constitutional problems apart from this judgment's application on the same. I believe that Mr. Hamza's election was otherwise very controversial, illegal, unconstitutional for various reasons. But since we are here to discuss the applicability of this judgment, I think if this judgment was to be considered, then the most important impact that this judgment might have is going to be seen tomorrow when Election Commission of Pakistan is going to decide the fate of these dissidents whose obviously the vote has been challenged by Pakistan Tehreek-e-Insaf. So I'm afraid that the case might be adjourned, but the Election Commission of Pakistan must decide this case in light of this judgment of the Honorable Supreme Court, which is very clear, which says that they could not have voted. Their vote does not count. So if you remove their votes, then of course the very election of Mr. Hamza Shahbaz Sharif is questionable, and there is no chief minister. And I think now this reason also adds to the already existing reasons, such as the resignation of Mr. Buzdar and the way that election was conducted and all of that. So I think they've got some serious constitutional crisis coming very soon for the PMLN and the party in government.
But the thing is, even though the ECP, whatever the ECP may decide tomorrow, ECP is deciding on the defectors deseating, right? The decision today refers to the fact that whether they're deseated or not, their votes do not count. So it's a different decision, right? So the question is the fact that the Supreme Court has made this decision after Hamza Shahbaz Sharif has already supposedly been elected. Does that impact his election?
It does, and I think at the end of the day, Hamza Shahbaz's election or the ECP's decision and the Supreme Court judgment will be linked one way or the other, because tomorrow the most important precedent that the ECP will be using is the Supreme Court's judgment, because prior to this judgment there was some confusion on the applicability of 63A. So let's say if tomorrow they were in the mood not to deseat them on the basis that 63A doesn't apply, that is now removed. So the Election Commission of Pakistan is just left with an option to deseat them, number one, and secondly, hold that their vote had never counted. They had not voted in the first place. So therefore, situation becomes abundantly clear after this judgment. It is now mere details in the process that has to follow. And if the Election Commission of Pakistan delays it, then it will speak volumes about their conduct on how they are conducting their institution under Article 218, 219, 220. They are bound to conduct the elections freely and fairly, and even otherwise, their conduct has to be far above excellence. Here, if they delay it, I don't see that happening because they were quite hasty in deciding the dissidents' election, fate as far as the National Assembly is concerned. So I expect the same haste and the same eagerness and the same willingness, the same intent when it comes to deciding this.
Okay, so if we leave Hamza Shahbaz Sharif decision on whether he is the CM or not, the Chief Minister of Punjab or not, to one side, the fact of the matter is right now he still doesn't have a cabinet in Punjab. Now we have the Mustafa Impex decision in the federal government of 2014, which says what is considered a government is a cabinet plus the prime minister. Now, does the same decision apply to the chief minister and the province? And what
Yes,
does
it
that
does.
mean for our government?
It does. This Mustafa Impex decision was passed by a bench which was headed by Justice Saqib Nisar, Chief Justice as he then was, which was later ratified once again in the review. So this judgment has attained finality. As per this judgment, the very meaning of federal and the provincial government entails the Prime Minister and the cabinet, federal cabinet, Chief Minister and the provincial cabinet in the province. So any decision that Mr. Hamza Shahbaz Sharif takes at the moment, except those decisions where the constitution uses the word chief minister or the prime minister, as the case may be, except those decisions wherever the word federal government or provincial government, since we're discussing provincial government, comes before us or is mentioned, Mr. Hamza Shahbaz Sharif is taking illegal decisions. He is in no way, I'll give you one example, is to the removal of the Advocate General Punjab, then the very removal of the Governor of Punjab. So all these decisions, I think, are gravely hit by the very concept which was put forth by Mustafa Impek's decision. And this decision, I believe, is very relevant at the moment. It is only Mr. Hamza Shahbaz who's predominantly roaming around on the streets of Lahore. Except him, I don't think so. He has got a government to support his actions.
On a decision, on a constitutional decision like this, the Supreme Court has taken over 58 days, close to 2 months to come to a decision. And this was when it was expected in the first couple of days. This has had massive implications on a national level. I mean, why do you think it took the Supreme Court so many days? Because right now, as it stands, it means that Shahbaz Sharif's government in the center only stands on one vote. And had this decision come earlier, maybe the allies would have thought differently about joining the national government.
I would like to quote the great Mr. Etazaz S. And I was part of a program on Channel 92, Mr. Mohit Pirzada. I was there, and we took Mr. Etazaz S on online. And I asked this question specifically to him. I said, don't you feel that the very reference itself should have been decided with the cases that Supreme Court decided, and Mr. Etazaz agreed. Why? Because it has a grave implication as far as the very outcome of it is concerned. So now, even if this decision was given maybe 10 days earlier or 20 days earlier, we wouldn't have seen so much of constitutional crisis in Pakistan. But then, once again, we are nobody to comment on the very working of the Supreme Court of Pakistan. It is up to them to decide as much time as they, or take as much time as they want to decide a particular question, which involves a question of, you see, public importance. And there is also a very interesting part about this judgment, which is being discussed, that this opinion does not have a binding value. So let me clarify that, and I would request if you take me towards the end of the decision, the last paragraph of the decision that clarifies a in in light of the previous judgments which have been passed on this subject, Hisba Bill case, which is 2005, and then reference opinion number 1 of 2020, which was the Senate poll case, it has been made abundantly clear that it is of binding nature. However, if I read out the last paragraph with your permission, it says the short order disposes of pending matters under Article 186 as well as Article 1843. What has been said herein above is to be read and understood as a simultaneous exercise and are thus relatable to both jurisdictions that vest in this court. Now, this is very important. The jurisdiction that vests in the Supreme Court of Pakistan under Article 186 is that of advisory jurisdiction and advisory opinion that it is capable of rendering. And that opinion itself is binding. However, even if we were to argue that that opinion is not binding, and we move on to Article 1843, that is the jurisdiction where they have the authority to take up any matter of public importance or violation of a fundamental right. So even if you look at it from that point of view, I believe they sort of come within the ambit of a binding advisory nature of this judgment, opinion, decision, whatever it is. It is binding as far as my humble opinion is concerned. So the government cannot wriggle out of it and must not wriggle out of it because Supreme Court has discussed it in the past. When you seek our opinion and when you ask a particular question which is posed to the Supreme Court of Pakistan, then you ought to take it seriously. Because at the end of the day, one way or the other, this case is going to land in the Supreme Court of Pakistan. To avoid multiplicity of proceedings, to avoid multifarious litigation, it is important that you decide it in the nub and you don't bring it to us when we've already rendered our opinion. I mean, it's pointless to ask if I ask you a question and I say that what is your opinion on that, and then later I file an application for you and say, okay, now pass a decision. Of course, it is going to be the same decision. Supreme Court cannot deviate. Otherwise, it will be pointless to understand that why would it think differently in a different case.
Ahmed, my final question is a little bit on, we're hearing rumors that a technocratic government may be set up to resolve the economic issues that we're seeing in Pakistan, so that given the fact that it is seen that no political government will take the tough decisions such as, hiking petrol prices, hiking interest rates, or hiking, given the inflation that's taking place, taking all the tough decisions of restricting spending and so on. Um, and the fact that this technocratic government may last for months on end. Now, is there a constitutional provision for that? And it's important because I'm not a legal expert, but I know that if the former Chief Justice, if the Chaudhry had given decisions on this, that technocratic governments shouldn't last longer than 90 days. What are your thoughts on that?
Well, I'll be very clear and candid on that. Anything which is beyond the purview of the Constitution must and should not be allowed. Your question relates to the formation of a government of a technocratic nature, which does not, unfortunately, which does not trace any sort of power from the Constitution of Pakistan. That exists is with respect to the only provision that exists is with respect to the conduct of an interim government, that too for the purposes of polls. And you've just mentioned the judgment by Fatah Chaudhry as well. And I think we must not even think about this interim structure where the technocratic government takes place, because I'm personally not in agreement with that. Because then you've got all those military men and all those funny people jumping in and trying to improve Pakistan within a period of 90 to 100 days, which doesn't happen. So I will be very clear as far as that point is concerned. This office is only meant for people, the chosen people, people who are elected by the electorate, and nobody else, except those 3 months or 90 days maybe, which the interim government can continue, and that too under the constitution. So let's not try to read anything into the constitution, which of course there are several forces which are trying to decide. Difficult decisions can be taken by anybody, and I think if at all somebody should take these decisions, it should be the interim government.
Ahmed, thank you so much for your time today.
Pleasure. It's a pleasure. Thank you.